We're the self-actuated. We introduce ourselves. I'm Bob Kaiser. I am from New Jersey. We have called this panel Stories from the Front Line. We've also called it the continuation of the villainization of the tax lien industry. I also have a sub-name for it, which is that the definition of disappointment is the distance between expectation and result. And so what we're going to do here today is try to lower your expectations so you don't experience disappointment. It's a legal concept. You'll get it. Anyway, I'm Bob Kaiser. I'm from New Jersey. Seated to my left is the representative from the middle of the country, hence his location. This is Michael Wilson from Chicago. To the far left, on the left coast, is the bi-coastal law firm of Manoil, the smallest national law firm in the country, consisting of two partners, one on the West Coast, one on the East Coast. We have the West Coast version from Arizona. He is actually in charge of Maricopa County, along with Sheriff Joe. And what we're going to talk about are the challenges that you actually face in each of our jurisdictions, not challenges based upon adverse publicity, but challenges in the day-to-day that have been visited upon us either by judges, by perhaps changes in legislation, perhaps dealing with the administrative process. Each of us has our own stories. We're going to assume, for the sake of this discussion, that all of you have a rough idea of how the process goes in each of our states. None of us are going to describe the foreclosure process, except that I'm going to say ours is a judicial foreclosure state. You buy a tax sale certificate, you hold it for 2 years during the redemption period, then you foreclose. At the end of the day, a judge enters an order and you own the property without a sheriff's sale. So you now know all you need to know about New Jersey. I assume you guys will also let them know what they need to know. And by the way, we're also going to have they can butt in so that if I get too boring or start to run on too long, they can take over. Anyway.
That's the case in all three of our jurisdictions,
right? We have no tax deed states here. How about that?
Yeah.
I guess one of us should leave the stage. And does anybody want to join us so that we can get some real variety? Anyway, in my practice, the majority of my clients are in it for redemption. And so the process that I undertake most of the time leads to redemption. However, I have some clients who crave real estate, and they just have gotten into this practice saying, at the end of the day, I'm going to get this property. And it is really about those clients that I speak, because the issue now in New Jersey is when I go through this process, this tax foreclosure process that ends up with them owning a piece of real estate, can I make it stick? Can they continue to hold the real estate? And over the early part of my practice, whenever I finished a final judgment, in a certain percentage of cases, I could expect that it would be challenged. And the challenges usually fell into two categories. One, which is one that everybody understands, was due process followed? Did I get people served? And there could be any number of reasons why they would say I didn't serve them. The most common, enjoyable one is the husband and the wife were having an argument that day. You served the wife. The husband never found out. That actually works. But we understood that. The second typical challenge was what I call the Mrs. Costs challenge. Mrs. Costs was in a case called Bergen Eastern versus Costs. It's the last time I'm going to give you a case name. And Mrs. Costs wasn't, I have to say this politically correctly, she was on the older side. She wasn't completely with it. And she was unrepresented. So Mrs. Costs, as she explained to the court, didn't understand the gravity of the situation. So when she lost her property, she was able to come into the judge and say, I'm a little elderly. I'm not totally with it. I didn't understand the gravity of the situation. She probably had an attorney say that. I doubt that she said it herself. So Mrs. Costs was able to redeem after the final judgment. Judge said, this wouldn't be right. We're going to give her her property back. She has to pay, understand. She didn't just get the property back. She had to pay the taxes. So now we get, in any number of cases, the Mrs. Cost defense. Everybody has some kind of an illness. Everybody couldn't understand what was going on. And so therefore, they should be entitled to redeem after the, say, 3.5 years between when the tax certificate was sold, when we finished the foreclosure, because you can redeem in New Jersey all the way through the foreclosure process up until the day the final judgment is entered. And we got used to that, and we won some of them and we lost some of them. And frankly, when you got the motion to vacate your final judgment, you knew right away, this guy's got a good story. No, he doesn't have such a great story. That was all accepted, and I could predict for my client when they were going to get to keep the real property. But here's what's happened. In recent years, we've gotten to a new type of defense that is beginning to work almost every time, and that is, it isn't fair. It just isn't fair. And I'm going to tell you the story about Joe. His name would be changed, but it actually was Joe. You won't know any other part of it. And Joe was not a homeowner. Joe owned a gas station. It was one of Joe's investment properties. He didn't operate a gas station. That would have made his hands dirty. He had someone else operating the gas station. Joe didn't pay his taxes for a bunch of years, and my client bought a pretty hefty tax sale certificate. And if you know the way it works in New Jersey, you know that you bid down the rate. And if you bid it down to zero at the sale, then you start to bid a premium. This case had a pretty significant tax lien and a pretty significant premium. So we foreclose on Joe. Joe, important to know, has counsel from the beginning. Joe files an answer. Joe's answer is meaningless. It's struck by the court. He says, I wasn't served. He said, I was sick. He said, what he didn't say was, I don't owe the taxes, which is really all the judge is looking for when you file your answer. Do you have the taxes? Well, yeah, I did. Okay, your answer is stricken. So we strike his answer. We go to final judgment. Great. Client's got a buyer for the property. In the meantime, by the way, just to give you numbers, the property may be worth between $400,000 and $500,000, where tax lien at that point is up to about $100,000. This would count as a home run, okay? Home runs in the tax lien business in New Jersey are, by definition, perilous at best. So Joe takes an appeal with counsel, that same attorney who got his answer stricken. Joe's appeal goes up to the court. Joe files the motion. Files the motion to vacate the final judgment. Makes all these arguments. Judge looks at it all and says, nah, Joe, I'm sorry. You had your chance. It's been now 3 years. You didn't redeem. That was long enough. You weren't too sick. Oh, by the way, don't argue you didn't collect rent from the tenant. That was your problem. He said, didn't collect for 5 years. Files an appeal. The appellate court takes 9 months. I'm on vacation. I get the decision from the appeals court. It doesn't say I win. It doesn't say I lose. It says, trial judge did a bad job. Send it back down to the trial judge. I want findings of fact and conclusions of law. Gives the trial judge a whole list of questions to answer. Terrific. So I said to my client, okay, so we're now 3.5 years into this thing. And if you're in the tax lien business, you know time is your enemy because the redemption is growing. We do it again. New trial judge. They send it to the chief. Chief has the appellate division decision, makes us brief it, writes a decision, answers each of the appellate division's questions, says at the end, Joe didn't make a case. They get to keep the property. Sends it up to the appellate division because Joe appeals it again. The appeals court rendered his decision about now 4 months ago.
Bob, sorry to interrupt, but what is the appeal? What's the issue on appeal?
The appeal is
it's not fair.
They were well. It's one of the appeals, but he also said they were wrong that I wasn't sick. They were wrong that I couldn't collect rent, so they were wrong for a lot of reasons. He appeals everything that the trial court found.
All the findings.
All the findings. He appeals on everything. What he doesn't say is, by the way, if the trial judge says on an equitable grounds you're not entitled, the appellate court has to find that the judge was just wacko. That's the standard. It's called the wacko standard. If the judge made a wacko decision, the appellate court said, nope, he was a wacko, that trial judge, so we're going to reverse it. Appellate court doesn't even address that. Appellate court says he had plenty of time. He wasn't sick. He owed the taxes. We don't give a damn about the fact he didn't collect rent. You, plaintiff, you were right in everything except for one problem. Property is worth too much. we can't let you take it. We're going to give him a chance to redeem. Now we're past 3 years, past 3.5 years. Joe, by the way, knows that we have a buyer. So Joe, not being an idiot, runs to our buyer and says, they don't own the property anymore. I do. Sells the property, redeems us. He gets to keep what's now $500,000. We get our $160,000. And the client is ready to kill someone. Because he's tasted this money. He's already spent it. It's the expectation was, we've done everything right. We've got 2 trial courts that said we did everything right. We addressed all the appellate divisions. Now, what happens when the appellate court issues this decision? This is, by the way, an unreported decision, which for you non-lawyers means it's not supposed to be precedent. Other courts are not supposed to be able to rely on it. If they want it to be relied on, they have to publish it. But these days, everything that comes out is available to everyone instantaneously. Immediately, I'm getting all these calls from my tax lien brethren saying, you're going to appeal that, right? You're going to take that to the Supreme Court because we're all going to get killed. Because now we know there's a new standard for vacating a final judgment. It just isn't fair. So now I'm getting motions just in the last 4 months to vacate my final judgments with a copy of my decision attached to the brief to vacate the final judgment in case I didn't remember what it said. They want to make sure that they remind me. You remember that case with Joe that you had? Well, here it is. Take a look at it because we're giving it to the new judge. We want him to see that if he doesn't base his decision on the it's not fair, he's going to get reversed. And trial judges hate to be reversed. So they are all now saying, well, the appellate division has told us we have to consider what the difference is between the equity or what the equity is in the property. What's the lien to value? I'm thinking to myself, am I supposed to instruct my clients to look for bad properties now so that they can preserve their final judgments? I actually made this argument recently. It was not a winner. I said, Your Honor, if we're going to apply the standard, does that mean in the better neighborhoods, you have a better chance of getting your judgments reversed because there's more equity? So if I take properties in the not as good towns, those can stick? Oh no, we would never say that. That would be discriminatory. We couldn't say that. But I just lost one in Princeton. If anybody of you know about Princeton, you don't get a lot of tax liens there. That one happened to have been in an estate where 4 or 5 of the heirs couldn't agree to pay the taxes for years. And we took final judgment. 2 of the heirs filed separate contesting answers with counsel. We had them both stricken. At the end of the day, the judge said, sorry, this property's worth too much. We just can't let you have it. So I'm going to speculate 2 reasons why this is happening. One, as we said before, the villainization. We are in a major league mortgage foreclosure crisis in New Jersey, which actually hasn't alleviated as quickly as the rest of the country. And each of these judges thinks that they're dealing with just an extension of those evil mortgage companies that created all these problems. Second, when you're a chancery judge in New Jersey, they give you the Solomon class, where they teach you how to be Solomon, which is to say, how can one split the baby? So when the judge is talking to me and he's saying, your client's going to get paid when I vacate the judgment. You understand that. They're still going to have to pay the taxes. So why shouldn't I just do that? Why should I not be able to say, I made everybody happy. I gave the property owner their property back. They had to pay the taxes. Your client got redeemed. I can go home and tell my wife what a good day I had at work. So I know that I'm faced with that whenever I go in on one of these things. But the question is, what do I tell my clients? And I have to tell my clients, if there is a property owner who is awake and alive, or maybe not alive, but his heirs are alive, because that happens as often as not, and you get a final judgment on a property where there is fairly significant equity, don't start doing what some of my clients do. Don't start improving it right away. Don't go in there before they filed that motion, which you say, well, how long do they have? Well, the court rules say they have, or the statute says they have 90 days, but the court will say if you can come up with any other reason, it's a year. So for a year, you got to sit tight and see if anybody's going to vacate that judgment. Or you got to risk that I'm going to be able to go in if you improve the property and try to get those improvements back as part of a redemption. Very difficult. One small alleviating factor is I can sometimes get counsel fees and costs associated with defending my final judgment as part of the redemption. Why? If I can say we did nothing wrong and all the court said was it wasn't fair, I said, well, if you're considering fairness, how come I've had to spend thousands of dollars of my client's money to defend something where he did nothing wrong? And the judge will say, you're probably right about that. And then I get to submit my certification of attorney's fees and costs, and that gets added. That's extra. That's not ordinary in New Jersey. In New Jersey, in case you don't know, we get a big $550 in counsel fees on redemption. So, if you're planning on taking it to Atlantic City, if there are any casinos open, don't wait for that $550. What can you do to protect yourself? Well, if somebody files a motion to vacate, you can settle it with them. You're not going to end up with the property, but maybe you can do better than just redemption. But remember, you can't do better than just redemption by saying you're going to pay more in redemption. Can't do that. It's illegal to take $1 more than you're entitled to in redemption. If you do, they will void your certificate. So, because the redemption is through the collector says how much it is, you can't say, nah, give me another $10,000 and we'll cool, or $5,000. But you could deed the property back to them. And that doesn't have to be for redemption. So maybe there's an advantage to them. Maybe, just maybe they're kind of tricky and they say, we've set up this little LLC over here. Instead of deeding the property back to us, why don't you deed it back to our family LLC so all those judgments you wiped off the records won't immediately come back, and we can help with a little, I shouldn't say this out loud, fraudulent transfer. Sometimes they will do that. Sometimes we'll say, we'll vacate the judgment and you assign us the tax sale certificate. We'll hold the lien on our own home. Now, you can charge more for the assignment than you can on redemption. They can only get what you're entitled to. But on assignment, you can get a little bit of the vigorish. You can get a little bit more for that. So there are ways that you can settle that you can do better. Don't pay me to fight it. As much as I like the money, I know these judges. I know the judge I'm going to go before. I know he or she is going to go with the it's not fair. I'm waiting right now for a decision, and I argued last Friday on no excuse other than we just forgot. It wouldn't be fair. I'm going to lose it. I haven't gotten the decision yet. But clients like REO and clients, this is a good property, not a great property, but a good property. So that's my tale of woe. If you're in New Jersey, you can make money. We have great interest rates. We have great penalties. We have high value properties. We have the highest property taxes in the nation. We even beat Long Island. So you can invest and you can make money and you can get good returns. But if you get a really good property, don't start selling it before the motion to vacate the final judgment has been filed. And anything else, gentlemen? We have a bankruptcy issue too, but we might not go into that to the end if we have time. Yeah? How does that affect title insurance? Well, here's how it affects title insurance. We have the 1-year rule. The 1-year rule, for the most part, and now we've gotten around it, is that you can't get a title policy to a buyer for 1 year. Why? Because they know our judges. Underwriters Council said, your judges are not going to let this final judgment stick, right? You understand that. We say, no, that's not true. We can make it stick, but we know in our hearts it isn't true. So they say, well, then your buyer can't get title insurance, but there's an exception to the policy. The exception is against the possible claim of the former owner to vacate the final judgment. It's not really a useful title policy. I mean, most lenders for buyers are saying, that's a little bit of a mellow, harsher, to say that the other former owner can come in and vacate the final judgment. Now, some title companies that know the business really well and know those of us who do it really well, will say, if you've got good personal service, meaning if we can satisfy them that due process has absolutely been locked down, we can get a title policy on the 91st day. Because like I said, there's a 90-day rule and a 1-year rule, and they're saying the 90-day rule is the one we're going to use. And so their Underwriters Council, they'll know who did the foreclosure, they'll review it, and they'll say, we think you're in pretty good shape here. Now, they change, underwriters change, underwriters' opinions change. And as this becomes more and more prevalent, as these decisions come out, I don't know whether that 90-day rule is going to stick, because more and more of them are now becoming 1 year. And when you hear about bankruptcy and you hear about the fact that now a final judgment in my state and some others could be a fraudulent transfer if somebody files a bankruptcy after you got final judgment, then that title isn't good for 2 years until somebody brings, because that's the statute of limitations on the fraudulent transfer action. They can say, you took my property, that was a fraudulent transfer.
Bob, is that 90-day period you mentioned based on New Jersey court rules?
There's a statute that says that you can challenge. It's not the automatic right. You can challenge a final judgment within 90 days. That's in the tax lien statute. The court rule that says 1 year is a general applicability any final judgment, meaning they're applying the
Rule
longer
60 type of thing.
Pardon me?
Motion to set aside.
Yeah, motion to set aside.
Okay.
It's there are all these reasons, and the last one, my favorite, which is Rule 4:50-1F, for any other good cause. Yeah. The first five are the specific. You got newly discovered evidence.
Fraud on the court.
Something happened. The last one, any other good reason. Well, that pretty much narrows it down. Yes. We are not. The client, after nearly 3 years of litigation, sort of lost its ardor for fighting. But the other thing that the client did was make an incorrect assumption. They said, there's no chance this guy's going to redeem. And sure enough, the next day we get word from his real estate attorney, he's under contract. And he was mad after that. And by the way, you understand, like many Supreme Courts, you don't get the automatic right. In New Jersey, you file a petition for certification, and you got a 1 in 50 shot at getting it considered. I've been up to the New Jersey Supreme Court 3 times, but that was back in the days of the famous title rating cases when everybody was really excited. But whether or not this would have been enough, I can't tell you. But here's my big problem with this. What is enough and what is too much? Is a court going to start balancing it and say $50,000 is too much equity, but $20,000 isn't too much equity? I mean, how are they going to know when it's too much? Are they going to start putting numbers on this? That's going to get very strange. Gentlemen, I think I've used up my time.
Thanks.
You want the microphone?
They might not want to hear me, but as Bob indicated, Illinois is a merchantable title state. You get a tax deed. It's fee simple title. You extinguish all mortgages and liens against the property. And one of the major issues that we're having in Illinois is the requirement of strict compliance. The Illinois Property Tax Code requires strict compliance with the notice serving provisions of the Property Tax Code. And the Property Tax Code in one of the sections sets forth the other provisions by section number that you need to strictly comply with. In 1998, in the case of Midwest versus Anderson, the Illinois Appellate Court very artfully defined strict compliance as strict, quote, strict means strict. That was all of the definition that we all got as to what strict compliance meant. In that case, the issue was the certificate number on the notice. The certificate number would read 96-0001234, and those zeros are just empty computer fields. The tax purchaser in that case, as many people did during that time, on their notice they would put the certificate number as 96-1234. And so the issue was leaving out those empty computer fields, the zeros. And the appellate court said if it is not exactly as it appears on the tax sale certificate, you did not strictly comply with the notice serving provisions. There was evidence in that case. They brought in the tax deed petitioner brought in the county officials in regard to the issue of if you would have brought that notice to us to get a bill to pay the redemption, would they still have gotten the correct bill? And of course the answer was, of course they would have gotten a bill. The trial court said there was no prejudice, no harm with leaving out those empty zeros, or those zeros on the certificate. The appellate court said in all tax deed cases, prejudice is presumed. So since 1998, there hasn't been more definition than strict means strict, but we have gotten more interpretation. And basically, as a result of the mortgage foreclosure crisis and the economic crisis that this country has been dealing with for many years, the courts have been much more rigid with strict compliance. To go so far as in 2011, I mentioned that there are certain provisions of the code that we have to strictly comply with in Illinois. Section 22-5 is the first notice that you have to send out after the tax sale. Within 4 months and 15 days in Illinois, you have to send out a notice to the taxpayer of record. That specific section is not mentioned in the strict compliance provisions. So everybody always thought it was a substantial compliance requirement, a substantial compliance notice, because you have a very limited amount of time to get that notice out, especially for anyone who buys in Cook County. You usually don't get your certificate for 3 to 4 months after the sale, so sometimes you have 2 weeks to get these notices out. It's not a whole lot of time. In 2011, the appellate court ruled that even though it's not set forth in the strict compliance provisions, we still have to strictly comply with Section 22-5, which basically turned the whole area for the last few years on its head because everybody considered it a substantial compliance notice and a lot of tax deeds were not being issued. Of course, we used it sometimes to our advantage for our tax buying clients. If they didn't want a property, we could say they didn't substantially comply, they didn't know, give them their money back. And that worked. But that defense is close to running out in a matter of time. But the subsequent to that 2011 case, there have been 2 other cases from the appellate court that have basically affirmed the prior and held the same way, that if there's the strict compliance of Section 22-5. So we're dealing with strict compliance issues. I just had a case that I argued, and unfortunately the judge gave the decision right on the bench last week in a strict compliance case. And it doesn't have to do with the information on the notice, it has to do with service. The lender is a foreign LLC from California. They registered to do business in Illinois in 2011, I believe it was. In the materials the application for registration to do business in Illinois, they have to list a registered agent. The only purpose of a registered agent is for service of process. They put down the wrong address of their registered agent. They continued to provide in their annual reports the incorrect address for their registered agent. We attempted service on their registered agent. It came back. It kept going out and it kept coming back. You have a limited serving period in Illinois of about 3 months to get this done. They come into court and claim due process violations because they weren't served with notice. And the court held that we weren't diligent in strictly complying with the notice serving provisions, even though they caused their own failure to be served. So these are some of the strict compliance issues that we've been dealing with in Illinois, and in different counties. Obviously, the application is different.
We call that, by the way, the "you should have found me" rule. I was hiding, but you should have found me.
Right. Yes.
We have those. You should have found me rule.
In addition to the strict compliance issues, we've been dealing with a lot of bankruptcy issues in Illinois. A property owner can file a Chapter 13 bankruptcy up until the last day of the period of redemption. And then in their plan, the courts have found in Illinois that they can basically extend the period of redemption for another 5 years in the 5-year plan, and make payments over 60 equal payments. But not only that, if they fail to make some payments and you come in and ask for relief from the automatic stay because of their failure to make the payments, the bankruptcy courts bend over backwards to assist the debtor, and they certainly don't want them to lose the asset. In a lot of these cases, the only reason that the people file bankruptcy is because they go to an attorney either on the last day of the period of redemption or a few days before. They don't have the money, so the attorney says, we can file bankruptcy. It's the only asset the people have. We can file bankruptcy, and we can basically put in the plan to extend it out over this period of time. And they're hoping that the tax buyer is not going to be patient and want to wait for them to fail and for their bankruptcy case to be dismissed. It takes a lot of patience, as Bob's client had the runaround through the case that he described. You can sit and wait for 5 years, and all you're going to do is get redemption. That's all you can get. And if you start accepting the payments and then you decide later you want out, and you get, which I'll explain in a little bit, a sale and error, and you get your money back, then you're dealing with issues because you took tax money from them, but then you got it back from the county, and it's a double, and they're being charged because the taxes go back on the property, and there's a double payment. They're being required to pay twice.
Do you get interest when they do it over 5 years?
I have had success going into bankruptcy court, and asking the court to give us additional interest over that time. There are some judges in the bankruptcy court that will, allow that. There are some that won't. The most successful tactic that I've had is working out an agreement with the debtor's attorney to, that they'll agree to it and put it in their plan, that they'll understand that it's fair that my client get a little bit more interest. So, there is a more prevalent bankruptcy issue that Bob touched upon that is currently in the Seventh Circuit Court of Appeals, and it's based on the fraudulent transfer doctrine. There's currently an appeal in the Seventh Circuit. The NTLA did file an amicus brief. The case has been argued. We're waiting for a decision. In that case, and to understand the fraudulent transfer doctrine, the property owner lost their property to a tax deed. The tax deed grantee took possession of the property. The tax deed grantee sold the property to a bona fide purchaser. The former property owner filed a bankruptcy for completely unrelated reasons than losing the property to the tax deed. The debtor's attorney filed a motion in the court to void the tax deed based upon the fraudulent transfer doctrine, because the transfer was for reasonably less than, it was for less than reasonably equivalent value. This fraudulent transfer doctrine is a doctrine to protect a creditor. So if you try to get rid of an asset and you sell it to your brother-in-law for $100, you sell your house for $100, it protects a creditor in a bankruptcy case. So a creditor usually will come in and ask for that transfer to be voided. And here they ask for the tax deed to be voided. The bankruptcy court voided the tax deed.
Not good news for the people who bought the property.
Not good news for the title company, the people who bought it, or the tax deed grantee. That was taken up to the district court. The district court reversed. based on a United States Supreme Court decision, BFP. I forget the full citation, but that's irrelevant. And it is now up on the Seventh Circuit Court of Appeals. We're anxiously awaiting that. If that decision, we're all reasonably confident that they will uphold the district court, because not only is it going to throw the merchantability of tax deeds out the window in Illinois and in other states across the country, possibly, the whole tax buying business will be extremely problematic in Illinois as a result of that case.
I think it's a really strong public policy argument, but are you guys familiar with the facts of that BFP case? Was it a tax sale coming out of the state of Washington?
BFP was a mortgage case. Oh. BFP was a case that involved a sheriff's sale. The Supreme Court got around the fraudulent transfer argument by saying that the sheriff's sale determined reasonably equivalent value. Anybody who attends a sheriff's sale in New Jersey knows that 9 out of 10 properties go for $100. They tend not to all be worth $100. So the fact that somebody was able to come up with and I understand also in the state where the case went up, it was roughly the same. Anyone who can base a decision upon the legal fiction that the sheriff's sale determined the reasonable equivalent value was trying to get to a result. Well, it
was an exposure to the market, right?
Sure,
Even
of course.
If it was a poorly attended auction, it was an exposure to the market. And what I'm getting at is whether your adversaries or the adversaries of all of the tax lien investors here could make an argument that in a tax deed state or a state like Florida, where there's a second exposure to the market and there's more, bidding activity is different than our jurisdictions, where you're essentially getting a quiet title judgment off of the tax lien. There's no further exposure to the marketplace. There's no more consideration, and so that the public policy argument is the strongest part of defending the titles that
you're
get,
you're absolutely
right?
right. You're absolutely right.
Yeah.
No.
Okay.
No, it's a foreclosure state. All of our states are the same. It's a certificate state, and then you do a judicial foreclosure. And as a result of the foreclosure, you end up with if you end up with a tax deed, it conveys merchantable title. You extinguish all mortgages and liens on the property.
That makes sense. But I think what you were saying, Tennessee, for instance, is a direct tax deed state. I think we have a very strong argument in that situation that has been exposed to that. And this could potentially, this opinion works in a tax deed state.
Right.
Right.
Not only tax deed, but also.
Well, that's one of the issues that was brought up in the NTLA's amicus. This doesn't just apply to to tax sales and tax deeds. It's across the board in a lot of governmental foreclosure types of process, and enforcement is going to be thrown up for grabs.
What's the name of the case?
BFP versus
that's the Supreme Court.
That's sorry, your case.
I don't remember the citation off of my head. I can get it for you and tell you outside.
What's the terminology that they used? The transfer was not for similar value?
Reasonably equivalent value.
The theory behind fraudulent transfers is a bunch of creditors out there are owed money by the same debtor. And if one creditor gets to take all the assets of that debtor, say the house, all those other creditors are out of luck because all the assets are now gone. So the theory behind fraudulent transfers, and it's been this way forever, it's state court, it's federal court, is you bring the asset back and then it can be divided up more fairly amongst the creditors. The problem, pardon me? Unsecured creditors, it could even be secured creditors. Remember, we wipe out all the secured creditors behind us too. So, the mortgagee who's behind my tax lien doesn't get anything either. And he's just as aggrieved by this alleged fraudulent transfer as the unsecured creditors because he didn't get paid on his lien. But I don't want to get into that argument. It's an unfortunate situation.
Michael, one part of this too is there's a very long period in this Seventh Circuit case that elapsed between when the tax deed was issued and when these people filed for bankruptcy. We're talking several years here. This wasn't some, oh, shoot, we barely missed it by a few days, let's file for bankruptcy.
Right, it was completely unrelated to the loss of the property.
And
So-
what was the time period?
I don't recollect the time period.
You basically,
do you know,
it's a
Stephen?
2-year statute. You have a 2-year statute of limitations from the transfer. I just had a couple of them filed, and they tend to be filed with bigger cases. At least in my case, I've got commercial properties, large tract properties, where the Chapter 11s were filed on the day before the 2-year, anniversary of when we took the property. And now with 3 big pieces of property. And, there is nothing that pisses a client off more than 2 years later being told, you might have to write a check. I said, write a check? What are you kidding? That's not easy to explain.
Is that the 2 years from the foreclosure judgment or the delivery of a treasurer's deed? Or how?
Well, from ours, it's from the judgment, because that's the day the title passes.
Oh, I see.
Yeah. Mark, we're going to have to let Mark, because Mark has this.
I'm almost done.
You're almost done? Okay.
I'm
We're going to
almost
leave him
done.
time, because he's got more work than the two of us put together. We got to let him do his stuff.
With the strict compliance and these bankruptcy issues, it's become difficult to sell properties
Yep.
as a result of tax deeds in Illinois. Same issue that Bob's having in New Jersey with title companies. However, in Illinois, they want this tax deed to season for 2 years because we have the 30-day rule and the 2-year rule. And so you have to hold on to it even longer. However, similar to this situation in New Jersey, if your attorney who did the foreclosure is reputable in the area, has a good relationship with his or her title company, can usually, after that 30-day rule, can convince the title company to insure. So it may not be as bad as it is in New Jersey in regard to that, but depending upon how this bankruptcy case goes, that sort of throws things to the wind. I just want to briefly touch upon, as in Jersey, most of the clients that we deal with make their money on redemptions. With paying subsequent taxes in Illinois and getting 12% interest on those subsequent taxes, and 90 to 95% of your liens redeem, that's where people are making the majority of their money, and where the people are coming to Illinois for. However, those items that we have to go in, file foreclosures, and ultimately they don't redeem, more and more people are coming into court, and it becomes harder to convince a judge to give you a deed. It's not impossible. We don't have the issues that are going on in New Jersey, where it just is based on those unfairness doctrines. One other thing that we have in Illinois which helps, there is a sale and error, what's called a sale and error provision in the statute, where if there are several grounds set forth in the sale and error statute in which you can file a petition for sale and error in court and ask the court give you the purchase price back, the subsequent taxes, and any costs that you had paid for this, not including attorney's fees, and you get your money back. Some of those even include interest at 1% per month from the date of the tax sale or from the date that you paid those subsequent real estate taxes. Some of those interest-bearing grounds are bankruptcy. So if there is a bankruptcy, either pre or post-sale, you can get your money back with interest, a federal interest in the property, or the one that I enjoy the most is the county official error. And we can find those a lot, especially in Cook County. Some of the non-interest-bearing basis are reimbursable municipal liens, bona fide attempts to get a tax deed, failure to strictly comply, substantial destruction of the property, or an environmental issue with the property. If you have a lawyer who's creative with the sale and error statute, sometimes you can take a property that's a negative property for you, and you can turn it into a profitable situation by getting the interest. And sometimes you can get one of those situations where you just don't want a property. Instead of taking a full loss on that certificate, you can get your money back. So I've had clients who have had horrible portfolios. They've had a lot of bad advice from people who were making the tax buys, or people made mistakes. And we've used the sale and error statute to take one client, it was about 500 certificates, and get them refunds, no interest. But man, they thought I was a magician. And so you can sometimes use that sale and error provision to your advantage, and either make a profit or at least get your money back. So those are some of the issues that we're dealing with in Illinois and some of the solutions to those problems. And there are more, but we've already taken up too much of Mark's time.
Well, I'm largely responsible for delaying both of you in finishing, but I just wanted to follow up that sale and error statute in Arizona is incredibly restricted, and you only have a sale and error if no tax was due on the parcel. It's a very brief statute, and it's almost never used.
Very liberal and liberally construed in Illinois.
Yeah, Bob, what's it like in New Jersey? Is
Closer to yours.
Oh, really?
Closer to yours.
It's pretty limited use?
Never happens.
Okay. Well, I'll go ahead.
Go for it.
Happy Friday the 13th, by the way.
For you triskaidekaphobes.
Yeah, thanks. That's good. Kraus, I hope this is working.
That's us.
Do I just push the
At least it
arrow?
was us years ago.
Hey, what do you know? Oh, thanks. And I guess
That's
I'm
the
supposed
picture
to-
of Dorian Gray.
just to turn this thing off. I'm sorry.
Just pick a button.
Okay. I've heard that I'm supposed to put this on for the benefit of anybody who might be paying attention. Wrong side. Sorry. Well, you know this part. I'm just going to talk about some things going on in Arizona. I was really fascinated to hear more about these bankruptcy challenges, and I've sort of been forming the opinion as we prepared for this that there seem to be a lot of ad hoc solutions to hardship that are being developed, and it might be worth another presentation or preparation of a paper or something about looking at historical precedents during, say, the Depression era, when the harsh remedies of the tax lien foreclosure system were trying to be modified by the actors, whether it was the public officials or judges. It seems like we're going through similar stuff now. The public officials seem to have this view of what our clients and our clients' lawyers do for a living that's kind of simplistic and superficial, and maybe not even this artfully drawn. In Maricopa County, which I want to focus on for new types of challenges that we are seeing, this is a nice soul-deadening slide for you to look at for a moment, but I did want you to see this. It's going from earliest years, so 2003 at the bottom to 2015 at the top in terms of each line. And I wanted you to see this for kind of the reality. As you probably know, Arizona and Nevada were states pretty much hardest hit by the mortgage bust in 2008 because the bubbles had blown up biggest in those states, with lots of speculation about property values just continuing to skyrocket, and the cost of new building, new developments was relatively low compared to other jurisdictions. So a lot of that activity was happening there, and so you can see the sale year 2008 was for 2006 tax liens. It's a 2-year difference. The tax year starts January 1st. The delinquency for the second half is in the following year, and then the auction for delinquent tax liens is the following year after that in the month of February. So it's a 2-year difference in terms of the year numbers. It's not quite 24 months. But you can see that the number of certificates here in the 2010 sale year for 2008 jumps from 8,000, wrong one. 22,000 liens sold to 25, then to 22, then to 19, and it starts going down as we get into the more recent years. While the average interest rates here
you can see are just kind of plummeting. The 2010 sale, that it was 8.62 in the average interest rate. It blipped up in 2011 to 10.8, and then has been steadily declining, so that this last February, when we had our tax auctions, it was 3.84%. And Greg, this is taken straight from the Maricopa County Treasurer's website, so you can find it if you want to look for it. Anyway, I wanted to point this out because, as you probably know intuitively, without having to see numbers, we had this giant bulge of delinquencies due to the mortgage bust. People weren't paying their mortgages, they're walking away from properties, abandoning them. That led to all kinds of problems, not just non-payment of taxes, but a lot of blighted property in the urban areas, or just abandoned properties that were then getting looted for their copper and their wiring and all the metals that might be in the buildings.
Don't forget their Viking stoves.
That's right.
They were taking their Viking stoves too.
So a lot of our work has been blight remediation. It seems like in terms of getting the title into the hands of somebody who's actually going to start by securing the property and then fixing it up and getting it sold. What I wanted to mention is this: with this background and this context that you now have, we had new legislation passed in our state legislature this year that was pushed by the Maricopa County Treasurer. And Maricopa County, for those of you not familiar with Arizona, is where Phoenix sits. Phoenix is the state capital as well as the county seat for Maricopa County. And it represents about 2/3 of the population of the state of Arizona and about 2/3 of the wealth of the state. Maybe 60% is in Maricopa County. So it's significant. But in this case, the Maricopa County Treasurer sort of went it alone at the legislature. He tried to persuade the other 14 county treasurers to go along with this bill that he pushed. And they said, no, thank you, not in our county. And I'm going to get into the details of that. I'm going to show you just a blip of his testimony at the legislature. But this is the bill that he advanced and got passed. Essentially, it rewrote for a Maricopa-specific version half a dozen of our tax lien statutes, which by itself I think is very poor public policy to create two tracks of law in our state. The treasurer himself drafted the bill, and with only a view to other statutes, not with any view at all or any input into Arizona case law about property tax liens. So he perpetuated or refreshed some ambiguities that are in the statutory language that had all been resolved by case law by his kind of crappy drafting. Excuse my language. But these are the kind of main takeaways of what this bill did. It allows for partial payments on delinquent taxes as long as the property owner pays at least 25% of the tax plus interest accrued and other fees with a payment. Most significantly to investors, I think, it does away with subtaxing. An existing certificate holder now still has the first right to pay the next delinquent year of taxes, but it's not added to their original certificate. Instead, in Maricopa County, starting next year, the next delinquent tax will be sold as a separate certificate if you choose to pay that. And the significance of that is that when it comes time for foreclosure, you're only able to foreclose the 1-year certificate unless you wait for the next certificate to mature for foreclosure, which if you were to take advantage of our subtaxing statute, it would be in the month of June. You buy the lien in February, next February in 2016, you will be buying the 2014 tax lien. The 2015 delinquent year would become available to you normally as a subtax in the month of June, and you could add it. In all of those other counties, you can still do that. In Maricopa County, they'll sell you a 2015 certificate whenever you elect to subtax, if we're still going to call it that. So I think what that means is, from a planning point of view, when these things become foreclosable, which is a 3-year hold period in Arizona, That means that instead of foreclosing, say, in February of 2019, we are a far-sighted group, by the way. Instead of foreclosing in February of 2019, you might wait till June of 2019, so you can at least foreclose 2 years together in the same action to kind of get back to the same idea of collecting multiple years at the same time. But this sort of, it has different names, I think. We haven't settled on one. It's either the kick the can rule, or it's the you have an option to retain your property for another year rule by just redeeming one tax year at a time and seeing if the market improves to justify your paying off the rest of your delinquent taxes that followed that 1 year. I don't think this is very well thought through. And then, as I mentioned, there's some language that the treasurer just picked up by copying other statutes that explicitly says the right to redeem continues until delivery of a treasurer's deed. We have case law in Arizona that says no, the right to redeem ends when a judge forecloses the right to redeem in his final judgment of foreclosure. Well, this has kind of resurrected this ambiguity that existed there. Michael, do you agree? I have a colleague here from Arizona sitting in the back. Yeah, so this may require some new litigation unless we can get that cleared up. I had met with the treasurer last week just to see if I was misreading some of this stuff. He calmed me down on some of the issues because I was afraid that on those partial payments I mentioned, that interest stopped accruing. But he assured me, well, as long as I'm treasurer, which is for about 1 more year, the CP holder won't be able to tell a difference because they just get paid out at the end once there's a full redemption. And if there isn't a full redemption with all those impounded payments under this new law, once the tax lien holder starts their foreclosure, those impounded amounts are returned to the property owner, and he has a choice of doing a full redemption or losing the property. At least that's according to the treasurer. Well, I'm sorry if I'm going to go on too long here. This is some detail you don't need to see. If anybody would like these slides, they exist. That's all I want you to know.
Currently, the law does not allow partial payments on delinquent taxes, property taxes. There is a precedence, make partial payments on delinquent sales tax and income tax, but not property tax. So this bill will allow that, and the need for it, as you can see from the chart there, is displayed by Kai. The number of foreclosures in 2008 was only 55. Last year it was 377. That's a 600% increase. I estimate that it will be about 450 this year. We are just starting the foreclosure process. It starts in February of each year. This time last year, there were about 3,600 new delinquencies added to the foreclosure roster. This year we have slightly over 5,000. That's the reason I'm predicting a higher amount. It's quite simple. It is cost effective in that it's less cost to the taxpayer to keep people in their homes than it is to put them on the street. And if we can reduce the foreclosures, there's judicial foreclosures, by allowing administrative parcel payments, that's less administrative cost to the taxpayers as well. It's pretty straightforward. I'd be happy to answer any questions.
So I think we can all agree that we want to cut down on jujitsu foreclosures.
Jiu-jitsu?
But I shouldn't be making fun of the county treasurer. But you notice that his presentation was we have lots more foreclosures than we did before the economic crash, and we need to do something about it. Corrales, I think I might need your help once more to get on to the next video. Oops, sorry. And this whole act kind of reminded me of another thing I'd seen recently, because I like Broadway musicals. So I wanted to share with you a couple of seconds of this little scene.
Are you Mr. Dunlop? Yeah? Well, either you're closing your eyes to a situation you do not wish to acknowledge, or you are not aware of the caliber of disaster indicated by the presence of a pool table in your community. Well, you got trouble, my friend. Right here, I say trouble right here in River City. Why, sure, I'm a billiard player. Certainly mighty proud to say I'm always mighty proud to say it. I consider that the hours I spend with a cue in my hand are golden. Help me cultivate horse sense and a cool head and a keen eye. Did you ever take and try to give an ironclad leave to yourself from a three-rail billiard shot? But just as I say it takes judgment, brains, and maturity to score in a bog-line game, I say that any boob can take and shove a ball in a pocket. And I call that sloth. The first big step on the road to the depths of degradation. I say first, medicinal wine from a teaspoon, then beer from a bottle. And the next thing you know, your son is playing for money in a pinchback suit. And listening to some big out-of-town Jasper, hearing him tell about horse race gambling. Not a wholesome trotting race, no, but a race where they set down right on the horse.
I'm sorry, I enjoyed it. Anyway, there are a couple of other things going on in Arizona that Arizona may not be the only jurisdiction where these kinds of things are happening, but we have a very restrictive sale and error statute, as I mentioned. I recently had a case that's actually still kind of pending where we foreclosed on a parcel that is somewhat close to the Colorado River, and it turned out after we foreclosed on it that the Bureau of Land Management, the federal government, was saying, well, how can you foreclose on that? We own it. And it turned out that I asked my clients, because they were getting a lot of pushback from the federal government on their newly acquired property, to get a full chain of title from the title examination company. And we went through this, and somewhere between the 1950s and the 1960s, the legal description of this property expanded from one section over into the next section to get to the Colorado River. And the assessor picked it up and just started assessing it, and that was the tax parcel, even though it included federal lands, for, 30, 40 years. And then we ended up foreclosing on a tax lien on that property after spending a lot of time trying to track down the owners who were avoiding service. Well, anyway, it now looks like the county doesn't want to treat that as a sale and error. They want to treat the refund of the money spent by my client buying the tax liens as essentially a tax appeal type of resolution, which has a whole different treatment in terms of the amount of interest that is earned. In Arizona, a sale and error actually is your money back plus 10% or the bid rate on your tax lien if it's lower than 10%. But the resolution statutes for tax appeals, for the ad valorem type of appeals, is like 3% interest, and they can hold back monies to different taxing jurisdictions like the fire district and make you wait until the next fiscal year to get your money. That's what they're trying to do in the small county. So that's another kind of challenge that may be a little more esoteric, but I think is quite possible. And then the last thing I wanted to bring up is that because we have a lot of blight in Phoenix, particularly as a result of the mortgage bust and abandonment of a lot of properties, with the combination of our SB 1070 law that came in at about the same time the mortgage bust was occurring, and that was the papers please local immigration enforcement through Sheriff Joe and other law officials. A lot of people just said, to hell with this, I'm getting out of here, and left the Phoenix area, and so that contributed to certain pockets of blight and abandoned properties. The city discovered in their abatement enforcement statutes that they have a super priority lien as well for abatement charges to board up or fence up houses, and it's junior only to property tax liens. So they have now embarked on a new enforcement regimen where they are filing lawsuits to foreclose their abatement liens, which ends in a sheriff's sale, subject to the property tax lien. So it won't wipe out the tax lien, it will simply be subject to that, and then presumably the buyer at the sheriff's sale will pay off the back taxes in order to have clean title. And some of my tax lien clients who are tracking these properties, who want to get those fix-ups, let's call them, are saying, well, I kind of want to protect my foreclosure rights even though they're a year or two away. So I will take the risk of paying off the city abatement liens, which may be anywhere from $2,000 to $10,000 that they incurred for boarding up properties. And the city's lawyers and the city they're confounded by this. They never expected this to happen. And they are now arguing that the tax lien holder, because they have a superior lien, has no right to redeem the city abatement lien to protect their foreclosure interests in the future. And it'll be interesting to see how this works out. This is going to be a litigation between now and the next tax lien talk meeting that we have. Yeah?
Why would they care if you're getting paid?
The city?
Yeah.
Well, I think that's a great question, but their response is,
They want the
as
property.
a public policy issue, we want to get the blighted property out of its current hands and into the hands of somebody who's going to fix it up sooner. So it's a blight remediation argument.
It's the perfect circle for the end of this, because what it means is we as tax lien investors are bad people, and so we shouldn't end up with the property. Someone else should, because we'll just keep it as a blighted property.
Somehow.
That's coming full circle to villainization.
Well, I think that kind of concludes my specific remarks. So,
And I think we've only gone about a half an hour past our time. So
sorry.
But
Very common for attorneys.
but we are not going to make any comments about keeping you from your next drink, because every other seminar session has done that. So that will not come up today. Thank you very much.
Thank you.